Hello, everyone. My name is Faith Gunderson, and I'm the marketing coordinator here at Schaefer Dean. And we want to welcome you and thank you for joining our July Business Builder. We know you're busy, so we appreciate you giving us your time. To make the most of your time, we encourage you to ask questions and participate by utilizing the chat box.
Thank you, Faith. I'm Doug Dean, the owner and managing partner at Schaefer Dean, and I'm delighted to have you join us today. One thing that I'm proud of at our firm is that we try to find ways to give back to the real estate agent community that we serve. One way we've started doing this is the Business Builder Speaker Series. The third Wednesday every month at 1 p.m., we bring a different speaker who's going to bring some content that will be engaging, educational, and help you develop your business. We've had a CPA talk about tax issues for agents, an IT professional talk about IT issues for real estate agents, and hope that you'll enjoy this session and get a good value out of it.
Before I go ahead and introduce Doug, I would like to let you know about our August Business Builder. It will be a little different than our usual Business Builders, which happen on the third Wednesday at 1 p.m. This will be on August 12th, which is a Thursday, and it will be a happy hour with Amanda Wilbanks, who is, she started Southern Baked Pie Company, and she's an author. She's been on the Today Show, but she started here in Georgia. So she's an entertaining and skilled speaker. So she will be joining us for our August Business Builder, and it will also be a fundraiser. So a portion of the sales made from the her pies sold there will go to benefit the Richard Schaefer's Memorial Fund.
Thank you, Faith. I really hope you can make this event for three reasons. One, it's an evening happy hour event, so it should be a fun time. Second, you'll get to try free samples of Amanda Wilbanks' pies. Amanda is an entrepreneur, and she's going to speak a little bit about how she grew a business from being a local pie baker to being on the Today Show. And third, a portion of the proceeds from the sales of the pies will go to the Rich Schaefer's Memorial Fund. My law partner, Richard Schaefer's, passed away July of last year, and there's a foundation in his honor that provides financial benefit to those who are undergoing cancer treatment and need some financial help. So it's a great event all the way around, and I hope you can make it.
So I just sent, before I introduce Doug, I just sent the registration link in the chat. So we're excited about this event since it is our first live Business Builder, and it will be honoring Richard, as Doug said. So welcome, Doug Dean, owner and managing director of Schaefer Dean.
Well, thank you, Faith. I mentioned that each month we present a different speaker, and we finally said, well, you know, there are legal issues that we'd like agents to know, and I know a great real estate attorney to talk about them. So I queued myself up to take one of our 12 Business Builder Speaker Series sessions. Bear with me just a moment while I pull up my PowerPoint. Our class today, my talk is on the top 10 legal issues that every real estate agent needs to know. I've subtitled it, The Top 10 Things That Closing Attorneys Wish That Their Agents Knew. Regarding the introduction, the legal notice, the presentation is general information for educational purposes. This isn't legal advice, and no attorney-client representation is created or assumed. We'll have 10 topics and 60 minutes. When I said I'm going to do a top 10 list, I didn't really think the math through. If we take an hour and a few minutes at the beginning for introductions and a few minutes at the end for questions, it leaves us about 4 to 5 minutes per topic. With that in mind, to make sure that we're able to get through all 10 topics, I'd like you to hold your questions until the end. To make sure you don't forget, ask questions in the chat feature. Once I've gotten through all 10 topics in the hour, I'll stay around as long as anyone would like and answer any questions. The first thing I wanted to talk about was some general contract language. Under Georgia law, the statute of frauds, contracts for the sale of real estate must be in writing to be enforceable. The minimum standards for a written contract are actually fairly low. We need all the pertinent P's, the parties, the price, the property description, and all the other proper and pertinent terms. But the contract doesn't have to be very fancy in order to be enforceable. There's a case about a cocktail napkin where two gentlemen at dinner sketched out the terms for a real estate sale, and they both signed the napkin. Later, one of them went to enforce it, and the other one said, that's not a binding contract. And the court disagreed. They said, why isn't it? It's a document in writing, signed by the parties, and it's sufficiently definite as to parties, price, property, and the other terms, and they actually enforced the cocktail napkin contract. The other thing to remember is it isn't a problem until it's a problem. A better written contract will consider all the various possibilities, addresses them, and includes timelines. When you're writing your contract, whether you're using GAR forms, the RE forms version, or a different document set, always use the proper and appropriate exhibits or addenda, and be sure to complete them fully. The contracts, be sure you use the proper community association disclosure and that you complete it completely. Same thing with the financing contingency. Use the proper financing contingency document and complete it properly. We did have a contract without a community association disclosure, and it was in a community that had a mandatory HOA. And without the disclosure, it made it very difficult to determine who's supposed to pay for what. The other thing I like to talk about with contracts are special stipulations. And here are my guidelines with respect to special stipulations. Sometimes we get special stipulation happy. We add lots of special stipulations. Try to minimize their use to when they're really truly needed. Second, if you use the GAR forms, GAR did a pretty good job of writing every special stipulation that you need. Use the GAR Special Stips Index, and I had an agent ask for a special stip for a boat dock on a Corps of Engineers lake that the seller was to transfer to the buyer. And when he looked at my direction, he found a GAR Special Stip exactly for seller dock permits on Corps of Engineers lakes. So they've done a pretty good job of writing most special stips that you need. Get help from your broker or an attorney if you write unique special stips. A poorly worded special stip is worse than no special stipulation at all. We had a contract with a special stipulation that said seller to provide copy of utility bills. That's all it said. The parties got into disagreement and each was trying to get at the other through the contract. The seller said, it doesn't say what utility bills. It doesn't say when I have to provide them. I was going to bring them to closing. It didn't say I had to provide them in advance. And you can see where this went from there. The other important thing is contact information. When you're writing a contract, include all the relevant information for each party in the contract. This is important for a couple of reasons. One, to comply with the notice provisions in the contract. If you're a buyer and you have a 10-day due diligence, you need to give the seller notice of your intent to cancel during the due diligence period. That's great. How do you do that if there is no contact information anywhere in the contract? How do you give the seller notice? About the only way you can do it is physically find the seller and deliver notice to them. And that's one of the reasons having good contact information for each party is important for notice provisions. I will tell you, it's also a little selfish. I like a contract that has good contact information. When you send me a contract, and the first thing I do is call you and thank you and say, thanks for sending over the new contract. By the way, how do I find any of these people so that we can start processing the file for closing? If you've given us good contact information that's present in the contract and accurate, we can work on your file more quickly for you. Sellers also need to provide contact information for loans, payoffs, for community associations, and the like. So the earlier we have their contact information, the earlier we can reach out to them. You can help us with that by telling the sellers, hey, you should be expecting a call from the attorney, and they're going to need your help with payoffs and HOAs and things like that. So please cooperate with your attorney to keep our closing scheduled. Another thing that you can provide timely to us are your commissions, the instructions to closing attorney. If you have a disbursement authorization or a pay at close letter for your commission, go ahead and get that to us so we can cut your commission checks promptly at closing. And anything else that you're responsible for. If you're responsible for a home warranty or the termite or the survey, make sure to get those to your attorney as quickly as possible. We had a closing where we had been asking the agent for the home warranty, and at closing, she was ordering it on her phone to be emailed to us, and we had to go back and revise the closing statement and add it and so forth. So providing these documents up front gives you a greater likelihood that you'll have a smooth and fun closing. The third item that attorneys like to remind agents is it takes time. We're pretty good, but we're not magicians. A lot of these things we can't procure after thin air, but we have to do some due diligence to get this information. Each step that a closing attorney needs to fulfill requires some level of time. Now, people have asked me, what's the fastest that you've ever done a closing start to finish? And the answer is, we had a buyer who was in pre-foreclosure. His lender was going to foreclose on the courthouse steps on Tuesday. On Monday morning at 10 a.m., he said, I found a cash buyer. Can you close it today? So we started at 10 a.m. We rushed to the title exam. We got the payoff from the foreclosing attorney, and we were at the closing table with a cash buyer by 3 p.m. that day. So a lot of things worked in our favor. There were no other loans or liens. The foreclosure attorney quickly got us a payoff. There was no HOA. A lot of things fell in place, but we actually started at 10 a.m., completed it at 3 p.m., and by 4 p.m., we'd wired the payoff to the foreclosing attorney. Now, most of the time, they don't go that quickly, and we do need some time to pull title, order payoffs, get condo or HOA documents, that sort of thing. Title exam, payoffs, and HOA condo letters are usually some of our pacing items. Make sure your sellers understand that they may need to prepay for a homeowners association or condo owners association letter up front. The GAR contract now puts that as a seller requirement to do that within 2 days upon the request of the closing attorney. We still get pushback on it. Even more time can be needed to clear up old issues on title. If we run title and we find, guess what? Your former owner of the property had a loan that doesn't show paid off on title. We're going to need to clear that, and that will also take a little time. Loans from prior owners not canceled of record are one of the common items that we see. Missing interest in title. For example, the property was formerly owned by a husband and wife, but it was sold only by the wife. And our title exam says, what happened to the husband's interest in the property? I don't see it in the deed records. And that's something that we have to spend some time correcting and researching. I advise you to confirm your closing date and time with all parties and the lender and schedule the closing in advance. I had an agent call me on Saturday to confirm his closing for Monday, and unfortunately, Saturday was the first I'd heard of it. Yes, we had the contract and we're ready, but no one had actually scheduled the closing. So fortunately, we had a little notice. We were able to pull everything together, but try to confirm your closing date and time with everybody, including the lender, and schedule it with your attorney well in advance. Payoffs, liens, and judgments. Our title exam guides the closing attorney to determine what items on title will need to be paid off at closing. The attorney needs to be responsible for ordering these items and having them sent directly from the creditor to the attorney. Sometimes people want to help and want to order a copy of the payoff. It's their payoff and they're certainly entitled to do that, but for a variety of reasons, including security and accuracy, I need to get payoff statements directly from creditors. But the seller's assistance might often be needed for a couple of reasons. We're going to need seller's authorization to order payoffs. We have a form for that, and it's part of the documents we give the seller early in the process. So payoff authorizations are one thing where we need seller's help. Sometimes we have creditors who just aren't very responsive, but the creditors tend to be more responsive to their clients than requests from third parties. Don't try to handle payoffs without including your closing attorney. And you think, why would anybody ever do that? Well, it happens. We have a seller who has a home equity line of credit and it has a zero balance. And he says, well, I don't want that to be a problem at closing. I'll go down to the bank, pay the balance, and close it out. And my advice is, don't do that. Work with your lender. Let us help you. The borrower closed and canceled his home equity line of credit prior to closing, but he didn't have the documentation. It showed up as an open lien in our title exam, and we needed proof of payoff. We needed proof that the lender was filing a cancellation or release in the deed records. And if he had just said, oh yeah, I have an open HELOC, we just said, great, we'll get a payoff. You can sign a closeout letter at closing. I appreciate him trying to be proactive, but it actually created more work. Another situation, a borrower had gotten it, or a seller had gotten into a dispute with her contractor who'd filed a materialman's lien. Fortunately, she called me first and she said, should I go to the materialman and get the payoff? And I said, don't worry about it. We'll take care of it. We'll get the payoff. It will be part of your deductions in your seller closing expenses, and we will make sure that the materialman lien gets canceled of record at closing. That's part of our job, part of what we do. Bankruptcies may remove personal obligations for debt, but they don't necessarily remove the lien against the property. And a lot of people in bankruptcy don't understand that distinction. Well, this was in my bankruptcy, and I acknowledge it was in your bankruptcy. However, it was a lien against the property, and it still is. It now has to be paid off because it's a lien against the property, even though you didn't have a personal obligation for the debt. My advice is if you have a seller who's had a bankruptcy, make sure that their bankruptcy attorney not only avoided the personal liability, but also, looking for the term, avoided the lien as well, not just the personal obligation for the debt, because they aren't two separate things. And if it was, for example, a mortgage tied to the property, in most cases, they had to reaffirm the mortgage as a part of their bankruptcy, so it doesn't go away. Sellers in bankruptcy often would need court approval for the sale. That's not a quick process and will take time. So if you have a seller in bankruptcy, make sure we know up front and can work with their attorney to get bankruptcy court approval for the sale. Community associations, HOAs and community condo owners association, we need to be responsible for ordering the letters, but we need everybody's help in this process. We need the seller's help in getting proper contact information for the entities, and we need their help to prepay for these letters that need to be ordered from the association. The appropriate party often has to pay, typically the seller, pay for these items up front. If they don't cooperate and don't pay these items up front, a couple of things start to happen. One, our closing date is potentially in jeopardy. We've got to have these letters to get to closing. The second thing is, you know, the old expression, you can pay me now or pay me later. If the seller doesn't timely pay for the letter and we get closer to closing, they can still pay for it, but now they might have a rush fee to get the information that we need to get to closing. Also, if the owner has a violation of HOA and condo requirements, these need to be addressed before closing. We will usually know because our letter will tell us any outstanding violations against the unit. So just be sure that your sellers are aware if they have any violations with their HOA or condo association, that they need to bring those current prior to closing. Community associations typically have lien rights. So the HOA or a condo owners association can file a notice of lien in the property records. But that's not their only remedy. Once it's filed as a lien, it's a debt like any other debt. And they can actually sue the homeowner in court and get a judgment lien. So we're talking about two different types of liens. One is your garden variety HOA or condo owner's lien, which they can slap in the deed records just by filing a form. But if they sue, they can get a judgment lien. So there are two different types of liens that HOAs and condo owners associations can create against the property. Make sure to use the property community association disclosure in your contract and make sure it's accurately completed. Under the GAR contracts, the seller may be liable for improperly or undisclosed community association charges. So you want to make sure that your seller gets good information from their association and accurately discloses it on this form. I talk about things as a pendulum, how they kind of swing from one extreme to another. Years ago, we didn't have all of this. It was kind of buyer beware. Buyer, go out, do your due diligence about your HOA or condo owners association. The seller didn't have to tell you anything, and the seller wasn't liable for anything. Well, the problem with that is in most cases, buyers couldn't get that information. The owners association said, we don't know you. You're not a member of our association. We're not going to tell you anything. So then we added a requirement the sellers had to disclose these fees up front, but there was no teeth behind it. So later the pendulum kept swinging and it said, seller, you must disclose these fees. Not only must you disclose them, you'll be liable if you don't accurately disclose them. So that's one of those areas where the pendulum has really shifted from the buyer to the seller over the years. Death and probate. You know the old expression, there are only two things certain in this world, death and taxes. This is the chapter on death. Later, we'll talk about the chapter on taxes. If an owner on title is deceased, their interest has to be addressed, either through the joint tenancy with rights of survivorship or through probate. The easiest way, if somebody passed away, is if they held title with one or more persons as joint tenants with right of survivorship, their interest automatically will pass to the co-owners upon their death. It doesn't have to go through probate and isn't part of the probate estate. So if I've got a husband and wife on title and one of them has passed away, what are we going to do? How are we going to handle that? Well, we're going to need a copy of the death certificate, and either the remaining tenant or someone else who is familiar with the death of the joint tenant will sign an affidavit that recites three key statistics. First, that they did hold title as joint tenants with right of survivorship. Second, that this person has died as evidenced by a copy of the death certificate attached. And third, by the joint tenancy language, the property now belongs to the survivor. So you can see how easy that is if someone passes away as joint tenants with rights of survivorship. All we need is a death certificate and an affidavit that can be signed at closing to transfer their interest to the surviving spouse. At death, if the property was not held as joint tenants with right of survivorship, all of the decedent's property goes into their probate estate, and no one can handle it until they are appointed as the personal representative for the deceased person. So remember, if it's joint tenants with right of survivorship, it automatically goes to the co-tenants at death. If it isn't, we've got to go through the probate process. Probate comes from a Latin word which means to prove. Sometimes I'll have people say, oh, here's a copy of my father's will, and it says that I'm the heir and I want to sell the property. And I tell them, that's great. Have you probated the will? And they say, no, I haven't. Do I have to? The answer is yes. We don't know if that's the person's last will and testament. We don't know if it's valid. The only way the will is given effect is when you take it to the probate court and it goes through the probate process and it is proved to be their final will, and now it will be enforceable. So you see how we take a will, we go through probate to get something that we can work with. The importance of probate is a couple of things. One, the probate court establishes this is the person's valid last will and that will follow the instructions in the will. The second thing probate does is it appoints a person called a personal representative, which is either called the executor if they died with a will or what we call testate, or they're called an administrator if the person died intestate or without a will. The third thing we look for in the probate process is that the personal representative was given certain, what we call statutory powers, including the power to sell real estate. If someone is appointed an executor, but not given the statutory powers, they don't have the power to sell. They have to go to the court and petition for permission to sell the property. That's not usual. Usually when we get somebody appointed as an executor or administrator, they're usually given the powers, statutory powers, including the power to sell at the same time. The other thing to know is everybody dies with or without a will. The expression I use is, don't worry, if you didn't write a will, the state of Georgia wrote one for you. It's called Georgia's Law of Intestacy, and it determines who gets your property if you didn't write a will. The key thing I want you to remember about intestacy is if someone dies without a will, Georgia law stipulates their property will be divided equally among their spouse and children, with the spouse getting no less than a 1/3 share. Now you can see what a problem that is. If a husband dies with a wife and 2 young children, the 2 young children now own 2/3 of the property. And we're going to have to get guardians appointed for the children, and it's really going to be a mess. So just be aware of that. Also, probate is a very mechanical process. We have standard forms. Probate courts use them all the time. So probate isn't difficult unless any heirs object or don't want to cooperate. But probate takes some time, typically several months. and there is no good way to rush or expedite probate. It's going to take the time it takes, which typically might be anywhere from 2 to 4 months. Entities and trusts. Entities like LLCs and corporations are created under state law, and an entity can hold title to a property just like an individual could. For example, my company, Schaefritz and Dean LLC, is a Georgia LLC, and I could title real property in my LLC name. Attorneys need to review corporate documents to determine who can sign for the entity and if the entity has the power to sell the real property. For example, I could put property in an LLC and stipulate that the LLC is not to sell this property. So that there are situations that do arise like that. So every attorney is going to look for the proper corporate documents to determine who can sign and determine that the entity has the power to sell the property. Agents should be doing this as well. When you sign a brokerage engagement, listings, and contracts, are you getting the proper person to sign for the entity? So just be aware of, one of the best things I learned in law school is you don't have to have all the answers. You just have to have all the right questions. If you have all the right questions, you'll know how to get the right answers. And just know if you're dealing with an entity, one of the questions is, do you have your corporate documents showing who can sign for the entity and that the entity has the power to sell real property? Let your party know the attorney will want to review your corporate documents. We also need to know in what state their LLC was created, because we're going to go to the Secretary of State and we're going to pull a copy of the documents showing, yes, the entity is formed and is in good standing. Entities must be in good standing with the Secretary of State. Typically, that's no more than just paying an annual registration fee to the Secretary of State. Trusts are a special type of entity. They're not registered with the Secretary of State in the same way that an LLC or corporation is. Trusts are created when someone drafts a trust document that contains a recitation of who is the trustee, who is the beneficiary, and what powers does the trustee have over property. And then we can title property not directly to the trust. We always title it to an entity as trustee for the trust. For example, title to Doug Dean as trustee of the Doug Dean Revocable Trust. It would be the proper way to do it. But again, when we have property that is held in a trust, we're going to do similar to what we do with corporate documents. We're going to look at the trust documents and make sure that the trust is properly formed, a trustee is named, and the trustee has the power to buy and sell real property. Because trusts can be lengthy and they can contain sensitive information, sometimes trusts have drafted what we call a certificate of trust or an abstract of trust. And that's a document drafted for this very reason. So I don't have to see the whole trust. I can look at the Cliff Notes, the summary version, and it will tell me everything I need to know. That the trust is validly formed, who the trustee is, and that the trustee has the proper powers to buy, sell, and hold real property. Next, I mentioned to you death is one of those certainties, and so are taxes. For property taxes at closing, we're going to determine that all the taxes that have been billed or issued up through closing are paid current at the time of closing. Property taxes for the current year are going to be prorated between the parties using the most recent information available to us. Current year or prior year, if the taxes are out, we're going to collect for them and prorate them. If they're not out, we're going to prorate them using last year's taxes. because that's the most recent tax information available to us.
Mr. Dean, are we doing questions at the end or questions as we're going through each section?
Yes, if you don't mind, if you'll just type them in the chat window, I'll take them at the end. And the reason that I want to do that is if I take them midway through, I won't get through all 10 questions in the hour or 10 items in the hour. If you'll just put questions in the chat window, that way I can cover all the material in the hour and spend as much time as we need for questions at the end.
Awesome, thank you.
Thank you. If prorations are made using estimated amounts, the parties agree to reprorate the taxes between themselves when the final bill is issued. I'm working with an issue now where we closed earlier this year, and at the time of closing, all taxes were paid current. Subsequent to closing, the seller had the property taxes for last year under appeal. The seller lost the appeal and the taxes for last year went up. And I explained to the buyer that the seller has an obligation to reprorate the taxes. And since this was for last year and they sold it this year, all of that tax bill should be borne by the former owner, by the seller. So we do see things like that. There are other situations where maybe the county will disallow the homestead exemption and make it retroactive for up to 3 years. And that puts us in a position of having to explain to the seller they need to go back and pay more in property taxes for the 3 prior years. So there are situations where taxes can change and the parties agree to reprorate them when the final bills are issued. Another thing I want you to know about taxes is Georgia withholding. The state of Georgia has a withholding tax for sales by non-residents of Georgia. The tax is either 3% of the sales price or 3% of the computed gain. And in most cases, it makes sense for the seller to fill out a short worksheet where they disclose how much did they pay for it, what improvements did they make, what are their expenses of sale, and what is their selling price. And we can net these together to compute their gain, and we can withhold for the state of Georgia 3% of the gain. There are also some exceptions to the state of Georgia 3%. For example, if you moved last year and Florida is now your home state, you're no longer a Georgia resident, but the home that you're selling was your primary residence for 2 out of the last 5 years, it qualifies as a primary residence under federal tax regulations, then it will still be exempt from the Georgia withholding. So there are some exceptions, and there's also a workaround about computing the gain and doing 3% of the gain instead of 3% of the sales price. There's also federal withholding. The US government has it's called FIRPTA, which stands for Foreign Investment in Real Property Transactions Act, is I believe the acronym. But FIRPTA stipulates if the seller is considered a non-resident, as it's defined in the US tax code, we have to withhold typically 15% of the sales price. There are some adjustments and carve-outs that can be made, but just understand if you have a seller who is not a US resident, there may be a 15% federal withholding. The other thing to know about both of these items is they are not taxes, they are withholdings. Once we withhold 3% to the state of Georgia, then the buyer can file a tax return, pay any taxes that are due to the state, and get them whatever money is owed back to them. The same thing with the federal. That 15% isn't gone forever. It's withholding to ensure that non-residents file a US tax return, pay any tax that may be due, and then they can get a refund of what was withheld if that exceeds what they actually owe in taxes. So both of those are withholdings, not taxes. And I want to make sure you understand the distinction. The other thing to know is that all sellers get an IRS Form 1099-S. It lists basic information about the sale, the sales price, the sale date, the property address, and the seller's name and tax ID number. This doesn't mean they have to pay taxes, which the seller will compute on their tax return, whether or not they owe any tax, just that the IRS has proper information about the sale. If it was your primary residence 2 out of the last 5 years and you didn't take business or rental deductions, most sellers can exclude up to $250,000 of gain for an individual or $500,000 of gain for a married couple filing a joint return. Divorce. If a seller is contemplating divorce, see if they can complete the sale before they actually file for divorce. If they can't wait, or they have already filed for divorce, make sure they are aware that their attorney will need to lift the standing order. Forgive me, these bullet points are out of order. Let me start at the top. When divorce is filed, a divorce court typically issues what's called a standing order. And a standing order prevents the sale of marital assets during the pendency of the divorce. And you can see what the public policy is for that. They don't want one of the spouses selling off property and running off with all the money while we're going through the divorce. So they put a hold on it and say, all right, you're going through a divorce. Don't sell anything till we get everything worked out. So that's what the standing order is. We find that in our title exam because part of our title exam includes a review of court documents. And that's the way we're going to find out about the standing order. Okay, great. I've got a seller couple in divorce and there's a standing order. What do we do? Well, the parties their attorneys can go to the court and request that the standing order be lifted and the court approve the sale. And this can be done, but it just adds a little time. It's a process, steps that need to be taken. So just be aware if your seller is contemplating a divorce, see if they can complete the sale before they file divorce so we don't have to fool with all this standing order. If they can't wait, or if they've already filed divorce, then tell them your attorneys will need to request the standing order be lifted. Another thing to know about divorce is even when divorces have been finalized, the closing attorneys need to review the divorce decree to determine and document compliance with the terms of the divorce and to make any financial payments required by the divorce. For example, the divorce decree may say the wife may have exclusive use and possession of the property, and upon the sale of the property, the net sales proceeds will be divided evenly between the husband and wife. If we don't check the divorce decree and know that, then the husband who didn't get his half is going to have a lien against the property. And that's what we're trying to avoid. So even if they've already completed a divorce, we're going to need to go through the steps to show that the sale of the property is in compliance with the terms of the divorce. Another thing I want you to know is that divorce itself doesn't transfer title. A deed must still be signed. So the divorce can decree the wife is to get exclusive use and possession of the property. The husband shall sign a deed to transfer his interest in the property to the wife. That's what the divorce decree says, but it isn't the wife's property until the husband signs the deed. And sometimes, for various reasons, the deed just doesn't get signed. Now, years later, the spouse wants to go sell the property, and we say, what about Joe? And she says, oh, that's my ex-husband. I got the property in the divorce. And I say, Joe never signed a deed to give you his half. We're going to need to find Joe and get Joe to sign a deed. And as you might guess, if they weren't getting along before, they're probably still not getting along. Joe's probably not going to be real helpful. Hopefully he will. hopefully he'll acknowledge, yes, that's what the divorce said. I'll sign the deed to release my half interest in the property. If he won't, in this case, the wife may have to go to court and sue him for contempt and compel him to sign a deed. And all of those are things that delay closings and add to stress, anxiety, and frustration. So just want you to be aware that these are how divorce items can play into real estate titles and real estate closings. Last topic I wanted to cover are mail-away closings or remote closings and powers of attorney. And forgive me, they're out of order again. Always let the closing attorney know as early as possible if a party needs a power of attorney or if they need a mail-away closing. If we know up front, we can be working towards it and make sure it will go smoothly. For a loan closing, the buyer's lender also needs to approve the buyer to use a power of attorney. We can prepare the power of attorney for the parties. It's specific to the transaction, says who is giving power to whom and for what purpose. Husband is giving power to wife to sign documents on his behalf for the sale of 1234 Main Street. And that's typically what title insurance requires. They want a specific power of attorney that's specific to that transaction. There are situations where parties have already drafted a power of attorney. Let's say the husband's in the military and he's overseas, and before he went overseas, he signed a power of attorney to his wife. There might be situations where we have to work with the power of attorney that's already prepared. Another example might be if one of our sellers is a senior and their mental condition was deteriorating, so they signed what's called a durable power of attorney. The durable power of attorney says, if I later don't have the capacity to sell real property, you can sell my real property for me. And in both of those cases, military POAs, durable power of attorneys, we can usually get title insurance company approval for these, but we just need to know up front, get the power of attorney, explain the circumstances to the title insurance company, and follow any steps they require to make that power of attorney work. Also, for mailaways, we're going to enlist another attorney, title company, or a mobile notary to oversee the execution of documents on our behalf, on behalf of the closing attorney. The people handling the document execution will have a fee to do that for us, and it's to be paid by the party that needs the mail away. The GAR contract is very clear on that point, that any party will pay any fee for additional expenses required by their inability to attend the closing in person. If the mail-away documents can't be executed the day before closing, funding might occur the following day when the original documents come back. So our buyer is signing on Monday, our seller signed on Monday in Miami, but we could not get the documents in advance on Friday. So both parties signed on Monday, but it won't fund until Tuesday when we get the seller documents back. Also be aware that the execution of powers of attorney and mailaways in other countries can be an extremely difficult process and add substantial time. We usually require an appointment at the U.S. consulate to provide a U.S. notary on documents, and there is generally a lengthy time period required to do that. We had one recently where our seller had lived in the U.S. previously, but he had returned home and was living in China. So we had to make arrangements for him to go to the U.S. Consulate in China to execute his documents. And that process was going to take 6 to 8 weeks. So we had to let the parties know this can't close for 6 to 8 weeks until the seller can get his appointment at the consulate to get his documents signed and properly notarized. This is the part when I say, congratulations, you have survived your 1-hour Business Builder Speaker Series on the top 10 things that closing attorneys would like real estate agents to know. In the words of the immortal Kenny Rogers from the song The Gambler, I hope you found an ace that you can keep. I hope you found some good information here that you can take away and will help you in your business for years to come. And thanks for your time. I hope you get some good information to take away. Remember that we are always here to help you for a great closing where everyone walks away happy. And you'll find my contact information on the PowerPoint slide. We will also send out the PowerPoint slides following the class, along with a thank you for participating. So now that we've covered the top 10, I want to go back to the chat window and open up the, you can unmute yourself and ask questions. Before you do, let me just read through the questions and ask those, and then I'll take any additional questions from the group. First, where do we look on the articles of incorporation to see who has the power to sell real estate for entities that are selling real estate? That's a great question. One thing I want you to know is there are two different things that you need to look at, two different things you need to do. One is look at the Secretary of State for the state where the entity is formed, verify that they are properly formed, and so forth. Now, the Secretary of State website for a corporation will typically list the officers, the president, vice president, and secretary treasurer. Usually they list 3 corporate officers. But regardless, I say don't rely on that. You ask the entity, may I see your corporate documents that indicate who are the officers, who is authorized to sign for your entity. So there's 2 parts. One is what can you get off the Secretary of State? And the second part is what can the entity provide? Just real quickly, I want you to remember 2 things about entities signing documents. If it's an LLC, we need to know, are they managed by their members or managed by managers? We need to know who those people are. They'll be identified in their corporate document called an operating agreement. It'll tell you whether they're member managed, manager managed, who the members are, who the managers, and will tell you who can sign and how many can sign. Can any manager sign and bind the company? Do all managers have to sign, or is it a majority? Or you'll find all of that in the operating agreement. It's similar, but a little different for corporations. Generally speaking, once you identify the corporate officers, any 2 corporate officers can sign to bind the corporation, or 1 corporate officer who has the corporate seal. So a president can sign and affix the corporate seal for the corporation. So that's this fairly long-winded answer on how do we determine who has the power to sell for entities. If you have an LLC and you are the sole person in the LLC, what do you need to be the signer? Great question. Remember, the requirements are the same, but they're a little looser for a single member LLC. A single member LLC should still have an operating agreement. It should say who is the member or manager, and is it member managed or manager managed. Even though it's a single member LLC, they could be manager managed, and the single member could appoint someone as the manager. So you do the same steps. Unfortunately, a lot of times we have single member LLCs where they never wrote up an agreement. And all we do is prepare an affidavit for them to sign that says, I'm a single member LLC. I don't have an operating agreement, but I am the only member manager, and I'm the proper person to sign for the entity. And in that single member LLC, we'll rely on that affidavit. Next question was, is there a difference between JT and JTROS? The answer is, I don't think so. I think it's just how people use the terminology. But I caution you to be very specific in the terminology, and here's why. in a deed, the default in Georgia is what's called tenants in common. So if we don't say, are they joint tenants or not joint tenants, then by default, they're not joint tenants. They're what we call TIC, or tenants in common. If we mean for them to be joint tenants, we have to recite, this deed goes to husband and wife as joint tenants with rights of survivorship. And that's the full language that should be included, which we typically abbreviate JTWROS or even JTROS. If you shorten it only to joint tenants, but don't have the survivorship language, it can create a question. Well, did they mean, it says joint tenants, did they mean joint tenants with rights of survivorship? So I think the best answer is be very specific with the wording. And I've even seen people who have gone on to say, as joint tenants with rights of survivorship and not tenants in common. So I've even seen that language. That's a little bit overkill. If you just say joint tenants with right of survivorship, that's fine. We abbreviate it often, but when it's used on the legal documents, it should be spelled out for clarity. For LLCs not registered in Georgia, are they automatically going to pay the 3% Georgia withholding? Another great question. The answer is not necessarily. For example, I can be a Georgia resident, but I can form my LLC in another state. And when I complete the paperwork, I'm going to list that the seller, oh, and the other thing I'm going to indicate is I don't pay any tax at the corporate level. The tax all flows through to me, what we call an S Corp. So I can legitimately sign the document and say that the seller is a Georgia resident because all the income flows to me. I'm a Georgia resident. I'm going to pay tax on it. I don't pay tax at the corporate level. So I think the question, if an LLC is not registered in Georgia, will they automatically pay it? And the answer is, like any good legal answer, it depends. It depends on how they're structured. It depends on how their taxes are. And it depends on whether the funds flow through to someone who is a Georgia resident and will report it on a Georgia tax return. Someone caught a typo in my materials. Odd that Marshall and marital got misspelled. Marshall and marital. They are marital assets, not Marshall assets. What's the best advice to give owners or sellers who do not reside here? For example, if they own investment properties, should they have an indefinite power of attorney on file with their property management company? It's going to get a little beyond the scope here, but like any good legal answer, I think the best answer is it depends. You don't want to give your property manager the power to sell real property, but typically you're going to have some agreement that they can enter the property, they can make repairs in emergency situations, and you wouldn't necessarily need a power of attorney for that. Usually that can be spelled out in the property management document. I think of needing a power of attorney when they're going to take legal action on behalf of the owner or the owner's entity, and that's where a power of attorney would come in. So I would recommend saving a power of attorney for where it's truly needed and address it through the property management agreement when that's appropriate. One question asked if we can do North Carolina closings, and unfortunately we cannot. The states that we are licensed in are Georgia, and we're also licensed as closing agents in Florida. We are working on getting our Alabama license here within the next month or two, but right now we're Georgia and Florida, and hopefully we'll soon add Alabama to that mix. So at this point, I have covered all of the questions from the chat window. I would encourage you, if you have additional questions, feel free to unmute yourself and throw out any additional questions. Stump the professor, as they say. Does anyone have any additional questions that we haven't covered? If
I do.
Go ahead. Thank you. What's your
Okay.
question, caller?
So if you, I love that. If you are just the listing agent, but you want to do like a general, I guess, title search, or if you're the purchaser and you want to do a general title search, like what are the steps besides going to the clerk of the Superior Court in that county to find out what's out there? How can you find other liens or whatever the case may be, so you're not surprised?
That's a great question, and I will tell you, if you're interested in doing a title search, I usually suggest asking whether it's your favorite attorney to say, can you have your title examiner pull this title for me? Often they can do it. They can do a current owner search. There are a lot of things we can do at a pretty nominal and reasonable cost. I have an expression that you might be able to take out your own appendix, but I don't recommend it. Let a doctor do it. You might be able to weed through the deed records and pull all the different things that we look through, which includes not only the deed records, the GED, which is the general execution document, the lien records, the probate records, the civil and criminal court records. We look through a lot of indices to make sure no one is attached to real property, and you might be able to do it. But my best suggestion is, if you need that, just ask your favorite attorney, can you do that for me? Can you do a current owner search and let me know what you find on title? I will tell you, I'm doing one of those right now, and it just happens to be on my very own parents' property. My sister is the trustee of the trust for my parents holding their property. And she said, will you go ahead and run a title search and make sure everything was done properly, putting it into the trust and so forth. So I'm doing a title search up front just to make sure everything is like it should be while they're getting it listed.
Thank you.
Oh, you're very welcome. Any other questions?
I have another one if nobody else wants to go.
I haven't seen any hands up, so it's your turn. Fire away.
Okay, so if you have a property that you bought at the courthouse steps, a tax lien property, then what's, after you do your 2-year waiting period, I guess here in Cobb County for their right of redemption, then how soon can you foreclose on it?
Well, first, and that's another good question. I want to back up and tell everybody a little bit about what a tax deed is. If an owner of real property does not pay their property taxes, the county can create a lien against the property called a tax lien. And if the tax lien isn't paid, the county tax commissioner can sell the tax lien to a buyer, a third party. And what they actually get is called a tax deed. Now, although it's called a deed, it's not what we call a present possessory interest in the property. You can't go into the property because you bought a tax deed, but you have essentially bought that tax lien. And if they don't take steps to remedy it, you can eventually get title through a tax deed. But the way you get title through the tax deed is, first, they have a minimum 1-year statutory period. You have to give them 1 year where they can repay you what you paid for the tax deed plus 20% and what's called redeem the property from the tax deed. If a year goes by and they don't redeem on the tax deed, it's actually only 1 year. I don't believe you have to wait 2, I think just 1 year. Once you've waited 366 days, 1 year plus a day, you can file in court to do what's called foreclose the right of redemption. Say, I bought this tax deed and they haven't paid it, and therefore I want to cut off their right to redeem the property from the tax deed. So once you go through that court process to foreclose the right of redemption, that's how you get good title. And that foreclosing the right of redemption process is a litigation process in court and might take anywhere from 4 to 6 months or longer if there are a number of other creditors who might object. Is that helpful? Does that answer the question?
Yes, and what if some people start filing liens in between the time that you actually do that process to get rid of their right?
When you file your tax, once you have obtained the tax deed and you foreclose the right of redemption, you're going to get what's called a super lien, and you should be able to cut off the rights of most other junior creditors except for other delinquent taxes. So once you foreclose, you might have to pay the other back taxes on the property you just acquired. But let's say they didn't pay their taxes and their HOA, and the tax lien got filed first, and you bought the tax deed. Later, the HOA files a lien for the back HOA dues. Since your lien was first in time, what we call first in time, first in right, when you foreclose the right of redemption, you should be able to cut off junior creditors, including in that case, the HOA lien.
Thank you.
You're welcome. Everyone has stuck around. Next question.
I have a question. Yes, please. So you said for title searches, when one of the other agents asked about how you could do them, and you said, you know, it'll be good to contact like one of your preferred closing attorneys, but like if they're swamped and you're trying to say go for like an auction property, what would be, is there like a limited title search that one can do or pay for, or what would be the best way to approach that?
Certainly, you can. One thing that you'll hear me say often is you are a licensed professional with specialized knowledge. You're a licensed real estate agent, and you can learn to do the same steps that either I or my title examiner would do. And that starts with a review of the deed records. And the way I find where to start in the deed records is I start with the tax commissioner, and they usually have a record of the most recent deed involving the property. From that, I can get either at the courthouse physically or through the GSCCA, that's Georgia Superior Court Clerks Cooperative Association. That's a website that all of the county clerks participate in and allows you to view deeds online. So I can start there pulling up a deed copy. Now, every deed should have two names. It should have what we call a grantor and a grantee. So I can work my way backwards. For example, if I know that I own this property and my deed was from Joe, I can go back in the deed records and say, where is the deed where Joe got title? Who did he get title from? And I work my way backwards. Once I work my way backwards as far back as I want to go, which if I'm doing a title exam is 50 years worth of owners, I come forward and say, okay, what did each owner do when they owned the property? So this is easily done on the GSCCA. It's a lot more cumbersome in person because they have paper books with grantor, grantee indices where you run all these names. So that's why title people look the way they do, because it's tedious work with all these books. But I'd start with the deed records, find the current deed, run it forward to see what have they done with the property. Did they take out a mortgage? Did they sell the property? Did they add anybody to title? And I would go backwards to see who did they get it from and what did they do with it. The other thing to check I touched on were the lien indexes. You can also do that on the GSCCA, but you're looking at the GED, the General Execution Document, the lien books, and so forth to see who has filed liens against the property. So that's enough to be dangerous to get you started, or how to get into the deed books, check them backwards and forwards, and how to check the lien books, use it for each of those names.
Question.
Yes, sir.
Okay, so I'm going back to probate.
Yes.
So the question I got is, I understand the joint, the tenants in common with right to survivorship and also a will. I know you talked about put the will in probate. Now, I was told also, what about if the if you have a trust set up? How would that work with probate? Would that be something better to have?
The answer is no one size fits all, but there are certainly situations where a trust makes sense. I touched on the fact that we're in the process of selling my mother's, the family home that I grew up in, that's been owned by my parents for virtually all my life. Well, my father passed away 25 years ago, and my mother was widowed and elderly, and we needed to put her into assisted living. And it really didn't make sense for her to stay as the owner of the property. So we put my family home into a trust, my mother's trust, with my sister as the trustee of the trust. So what that means is if we hadn't sold the property and my mother passed away, this property passes outside of probate because it's already in a trust. It's not in her individual name, so it doesn't pass into her probate estate. But like I said, not everything is right for everybody. In our case, it was a good solution and it made perfect sense to put it in a trust. My mom's still alive, we're gonna sell it, and my sister will actually be the one selling it in her capacity as trustee of the trust.
So, and again, you have to have somebody controlling, that authorized to control your trust.
That's correct. You're going to need really three things. First, you're going to need from the owner of the property. First, you're going to have to create the trust. Who's the beneficiary? Who's the trustee? And what powers does the trust have? So create the trust and then deed the trust from the owner into the trustee for the trust. And then the trustee can manage and care for the property as trustee of the trust on behalf of the beneficiary.
Thank you.
Oh, you're welcome.
Thank you, Dean, for that. Does that work the same way as the land trust that you hear about quite popularly?
I'm trying to choose my words carefully. A lot of the land trusts that I've seen, I'm not super wild about. I know enough about trusts to be dangerous, and there's certainly nothing wrong with creating a land trust, but a lot of them that I've seen, I think they pick up at a sales seminar, a real estate sales seminar. I don't think they're as detailed about the trust as they should be. To me, it's kind of like trust light. And there's nothing inherently wrong with them. I just don't always see them. You know, some of these land trusts might be 2 and 3 pages, and generally speaking, there's more to the trust than I see in a lot of the land trusts. Also, the term land trust is kind of a term of art. The term land trust has meaning in other states that recognize land trusts. For example, I'm pretty sure Illinois has a land trust statute. I don't believe Florida does, but Georgia doesn't. Georgia does not have a land trust statute, and land trusts make more sense in other states that recognize a land trust as a form of ownership. And that's why I say it's like a trust light. If you want to create a trust, go all the way and create a real trust, but the land trusts aren't specific. They make more sense in states that have that legislation, and Georgia doesn't. And I guess that's the overall reason that when I see something entitled land trust, it's like this came out of a seminar and it might work in another state that has land trust. And when I look at it, is it sufficiently detailed as a generic trust to do the things it's purporting to do? Does that make sense?
Yeah, yes, it does. Thank you for that honest answer.
Doug?
Yes?
Yeah, I want to piggyback one more time regarding the trust. I think we can get off of it. if let's say if I have a house in trust, I had somebody else as the controller of the trust, and if I want to sell it, could I sell it, or the person that's controlling the trust would have to sell the property for me?
Two answers to that question. The first question is, if it's in a trust with the trustee properly appointed and the trustee has all control, the question is, in your example, I'm assuming you're the beneficiary. Can you direct the trustee to do something or not? And it really depends on how the trust is structured. I've seen special needs trust where that is specifically forbidden. We don't want the beneficiary of the trust telling the trustee what to do. The trustee is managing the property for the benefit of the beneficiary, and the trustee has the full authority to decide when to sell, what to sell for, and all of this. So it really starts with, how is the trust structured and what powers are given to the trustee? And can someone other than the trustee order or direct the trustee to take some action, buy property or sell real property? And that's really going to be spelled out in the trust document as to what authority they have.
Thank you.
No, you're welcome. Interestingly, I grouped trusts with entities like LLCs and corporations. Obviously they have some differences. LLCs and corporations are creatures of the Georgia Secretary or the Secretary of State of the state where they're formed. Trusts can just be drawn up and a trustee appointed, but they do have some similarities in that we're taking title and we're putting it into, in one case, a trustee for the benefit of a trust, in the other case, not into the individual owners, but into an entity that holds it for the owners of that entity. So there are some differences, but there's also some similarities between trusts and entities.
And I got a question. If you're looking to, with the LLCs and like the S Corps, what would be the best way if you're looking to start an investment company, buying and selling houses? You want to have the business, put them in your business name. Would it be best to do an LLC or S Corp, or what's your recommendations for that?
Well, two thoughts. One is, people use the terms like S Corp and LLC, but they are different things. Remember that the entity is created under state law, and your options under state law are things like an LLC, limited liability company, a corporation, and there are a lot of other variations like a limited liability partnership, a lot of other things, but generally all we ever see are LLCs and corporations. What we call an S corporation is actually a federal tax election. So for example, Schaefritz and Dean is a Georgia LLC, but we file paperwork with the IRS that says, treat my LLC as a subchapter S corporation, which means the LLC doesn't pay any taxes. All the money, profit and loss, goes through the corporation and flows through to the shareholders. So that's what a subchapter S corporation is a federal tax election. So you could actually be a corporation that chooses subchapter S treatment, an LLC that chooses subchapter S treatment. Now that said, remember the best answer for any attorney is it depends. There are often little nuances. Generally speaking, without knowing any of the background and details, if you said, I want to buy real property, but I don't want to buy it in my individual name, I want to put it in an entity to protect my personal assets, and I'm the only member, I'd say based on everything you've told me, it sounds like an LLC with subchapter S tax treatment would probably be the right thing. Consult with an attorney or your tax accountant, CPA, but those all sound like reasonable steps. The reason that people create entities is to insulate their personal assets from their business investment assets. If you buy a property to renovate and somebody falls and gets hurt, in theory, they can only sue the owner of the property, which is your LLC entity. They can't come back to you personally and everything else you own. So that's one of the main reasons that people like to form entities, is to insulate liability. If you had bought that house in your individual name and somebody fell off the roof and got hurt, well, now they're going to sue you as the owner and everything you own, all your other property, your personal assets, and so on and so forth. So that's the reason a lot of times people do want entities. And that is, in fact, the name of it. An LLC is a limited liability company. And it's often used for asset protection like that.
Thank you.
No, you're welcome.
Dean, with regards to that joint tenants with rights, I'm sorry, the JTROS.
Yes, yes.
Can somebody name like their child a minor as can they co-own property with a minor, like if they have children or a child?
Can it be done? Answer, yes. Should it be done? In most cases, that's a bad idea. First, remember, if you add somebody on title as joint tenants with right of survivorship, you have just made them a co-owner of the property. You've given them a gift of half of the property, and you can't take it back. The only way to get it back is if they give it back, if they deed it back to you. So if you add your minor child on title as joint tenants, well, now if you want to sell the property, you're going to have to go to the probate court, get a guardian ad litem appointed who's going to have to represent the minor's half interest in the property. It's not like, oh, I'll just sign for my child. It doesn't work that way. They own a half interest and you can't act on their behalf. A guardian ad litem has to be appointed to do that for them. And if you want to go refinance your property, now you got to jump through all these same steps. So the first thing is, in most cases, adding a minor child to title is probably not advisable. Let's say it's a grown child. This is a grown child, and you say, I want to add them to title. Well, and my first question is, why? What do you want to accomplish? Why do you want to add them to title? And you say, well, I want it to go outside of probate. I want to make them joint tenants with the right of survivorship, and then they can have the property when I die. And I'd say all of that is accurate, but there might be other ways to do that. For example, we talked about putting the property into a trust, and they can take over the ownership of the trust when you pass away. Remember that once you put them on there, they're on there, and they don't have to give their half interest back. Also, if this is, even though they're a grown child, if they have any kind of financial problems, judgments are now going to attach to your property because they're a co-owner. So that's a long-winded answer. The short part was, would I recommend adding a minor child to title? And the answer is, in most all cases, probably not. What about a grown child? You can do it. Just talk through, why do you want to do it? Is there another way to do it? Do I understand all the risks of adding this person as a co-owner of the property? And are those risks acceptable to me?
Gotcha. Thank you.
Oh, you're welcome. Anyone else? If not, I'll say you've been a wonderful audience. Try the veal. I'm here through Thursday. I hope you've enjoyed the presentation, gotten some good information from it, and you've got my contact information. So let us know how we can help you grow your business. Go forth, conquer, have a great day, and we appreciate you being here. Thanks.